Okay. All right, and then this is the last notes from yesterday, so you don't need to type this out. You should already have it. All right, like I said, chapter 4 is the first couple sections are mainly dealing here with the amendments to the Constitution. All right, and remember, an amendment is just a change, right? Because when the founding fathers, when they left Philadelphia in September 1787, they just had the 7 articles. All right, it was the anti-federalists that kind of were what people like Thomas Jefferson were calling for, kind of these kind of amendments that would guarantee, at least in writing, certain freedoms. Right, that they thought that if it wasn't specifically listed, that the government could take from people and such. All right, and so yesterday remember how many amendments are there total in the U.S. Constitution? 27, which isn't a lot considering the 200 plus year kind of history that we have here. And we talked a little bit about it in chapter 3. It's not that easy to kind of basically kind of propose and pass an amendment. All right. So yesterday we were just strictly dealing with the First Amendment, which is just packed with a lot of freedoms. Right. So the last one, freedom of petition, is essentially basically you can sign a petition. You could basically kind of in writing, express your frustration, your opposition, or suggestion to the government. Right. What was another freedom that's listed in the First Amendment? Freedom of religion. Good. All right. And with that, you have things like kind of packed in there the Establishment Clause and separation of church and state. Right. So the Establishment Clause basically states that the U.S. government will not have a state religion. And that comes from our tradition coming out of Great Britain, where there is a Church of England that was established during the Protestant Reformation. They call it the Episcopalian Church here in America. All right. And so with that, you won't have a state religion, but also the idea that you should be able to kind of practice any religion that you wish within certain parameters, right? Like if I have a religion that advocates for human sacrifice, like I talked about in the video, I'll be going against other kind of laws and statutes, if you will. All right. But that idea that you're not forced to practice one particular religion. All right. And we'll talk a little bit about when we get into judicial branch. There's a lot of kind of court cases that kind of bring up First Amendment, bring up other amendments as the idea to kind of question or basically kind of justify, certain actions and such. So we got freedom of petition, freedom of religion. What's another one? Boom, freedom of speech, right? That's the big one everybody talks about. All right, the idea that you can criticize the government without essentially being arrested. There's places in other parts of the world where just criticizing the government can get you thrown in jail. All right. Within certain kind of parameters as well with that, with certain rights come responsibilities, as they say. And so the big thing that people tend to talk about is that you can't yell fire in a crowded movie theater when there's no fire, right? The idea behind that is that by doing so, my speech could hurt somebody if they're kind of in a panic and they run out and somebody gets hurt and trampled in that. All right. Now that doesn't go against, the idea of kind of people talk about cancel culture or whatever like that. And people get kind of upset, but companies, schools, if I stood up here and just, spouted off like some horrible stuff, the school can terminate me. All right. And I can't, freedom of speech, that's, again, you have with certain rights comes responsibility. So we got freedom of religion, freedom of petition, freedom of speech. What's another one? When you kind of gather together and go out and protest and, stuff like that. Freedom of assembly. All right. Good. All right. So you got that. And again, that's also within certain parameters as well. What else? What's another one? Freedom of press. Boom. Okay. And that's that idea that a kind of a free and independent press is important to the democratic kind of process. Certain countries have state-run media, which you only get one side of the story. In the United States and a lot of liberal democracies, you tend to have multiple news sources that are independent from government ownership. So there's a lot packed into the First Amendment. And those were the kind of things that a lot of those anti-federalists like Thomas Jefferson and people like that were kind of clamoring for. Particularly freedom of religion. Jefferson was the author of the kind of Virginia statute on religious freedoms, which you see a lot of that within the First Amendment. All right, so what I want to talk about today is the rest of the Bill of Rights. Remember, the Bill of Rights are the first 10 amendments. Those are the first changes. They're all kind of done at once to the U.S. Constitution. So the Second Amendment, which is somewhat of a controversial amendment, is the right to bear arms, basically own guns and such. All right, if you look at the wording of the Second Amendment, it basically states that a well-regulated militia is important to the kind of maintaining of the freedoms and such like that. So this one has been, and again, this is somewhat controversial in the sense like that you have certain things that certain like groups that are against the idea like certain states can require background checks. You have to wait so many days before you can purchase a firearm. If someone is in certain individuals believe this is basically states that the kind of concept of a state militias are individuals, all right, people that kind of like formed a lot of these kind of like militaries and before kind of a professional standing army. All right, so this one, again, like the issues with school shootings and stuff like that. Sometimes this amendment it kind of butts up against certain like kind of state and local kind of laws and such. If you ever rode the Metro Link, there's like a sign saying like no guns allowed and stuff like that. So there's certain limits on there. All right. And keep in mind, I don't think our founding fathers had any kind of intention like how like weapons would kind of improve over the times. They were mainly using muskets, but this was kind of a reaction to kind of the coming out of the revolution for some part. Third Amendment, no quartering of troops. That's a word you don't really hear very often, quartering. Do you guys know what that means, quartering? Housing. Yeah, housing. Okay. This is a kind of a direct relation to the kind of what happened prior to the American Revolution. After the French Indian War, which we talked about, the British had obviously military presence in the colonies there. In certain cases, people would be basically kind of forced to house British soldiers. So this was put in there this was kind of like fresh off of the kind of the memory that many of these people that signed the Declaration of Independence and that had remembered. This is one of the clamoring calls that they held for the kind of revolution. So this is an amendment that is, again, it's kind of reflective of its time. Today, this isn't an issue, really. You don't hear people like kind of like complaining about the Third Amendment or kind of challenging anything in the Third Amendment. It seems like an amendment that's kind of lost to kind of particular kind of an era, if you will. But it's still in there, just in case things happen later. Fourth Amendment, and as we get to kind of the Fourth, Fifth, and Sixth Amendments here, this is like kind of the idea like how the government should provide for certain things when it comes to liberties and that. All right. The Fourth Amendment protects against what we call unreasonable searches and seizures. All right. And so this idea here in with the Fourth Amendment, how the government can obtain material, obtain evidence when it comes to court matters and stuff. There's a lot of, and when we get to Chapter 7, when we talk about judicial branch, there's a lot of court cases that are kind of related to this, to the Fourth Amendment. All right. And this is an amendment that seems to kind of the interpretation of it changes. And somewhat, again, some of these stuff, while they're written, bless you, can be somewhat vague in interpretation in many cases. All right. So there's a number of court cases dealing with the Fourth Amendment and how the police in particular can enter your home or your vehicle or whatever and acquire what type of evidence at hand that can be used in a court case. There's a relatively famous court case I'm going to play right here called Chap versus Ohio that occurred in the 1960s. So one of the real first ones to kind of really give a distinct definition within the kind of the Fourth Amendment. I'm just going to play this real short here and we're just going to talk about it.
Chap versus Ohio involved a key question in American jurisprudence. The question is, what should we do when police officers commit an unconstitutional search? Should we allow them to use the evidence that they found, or should we exclude the evidence as a way of deterring police officers from committing unconstitutional searches? Chap versus Ohio involved a police search where police entered the home of Dalry Mapp. Whether they had a warrant to do so or not is disputed, and the Supreme Court ultimately assumed that they did not have a warrant. When the police were in the home, however, what is undisputed is that they found some incriminating evidence. For example, they found betting slips showing that Ms. Mapp was involved in illegal gambling operations. They also found obscene materials, which means that Ms. Mapp had violated Ohio's laws against possessing obscene materials. And the issue that the Supreme Court had to decide was whether that evidence could be used by the state of Ohio in criminal prosecutions against Ms. Mapp. Mapp versus Ohio is decided by a roughly 6-3 margin. The majority said that the exclusionary rule is part and parcel of our constitutional right to be free from unreasonable searches and seizures. The basic idea behind the exclusionary rule is that police officers should be given an incentive to comply with the Fourth Amendment. For example, if police officers are trying to decide whether to break into someone's home or to get a search warrant, if the exclusionary rule says the evidence will be excluded if they don't get a warrant, then maybe the police officers will have the incentive to go get a search warrant and comply with the Fourth Amendment. If you don't have an exclusionary rule, the majority justices said, then the police will be free to violate the rights of citizens because they'll know that there's no consequence to their illegal behavior. The dissenters agreed that the Fourth Amendment is a fundamental part of our liberties in this country, but took the position that each state should be free to craft their own remedies for enforcing those rights. So the dissenters would have allowed Ohio to decide to admit illegally seized evidence or exclude illegally seized evidence as it saw fit. The dissenters would not have imposed an exclusionary rule as some kind of constitutional requirement on Ohio and the other states. Mapp versus Ohio was a controversial decision when it was handed down in 1961. The common criticism is that it lets the criminal go free because the constable blundered. Why, critics of the exclusionary rule ask, should we let someone who's got a pile of drugs or a murder weapon in their home get off simply because the police made some kind of a mistake in collecting that evidence? And the exclusionary rule remains controversial even today. For example, in 2018, Justice Thomas, in a dissenting opinion, called on the Supreme Court to re-examine the basic constitutional underpinnings of the exclusionary rule. Justice Thomas suggested that the underpinnings weren't there, and it was time for the Supreme Court to simply abolish the exclusionary rule. The way the Supreme Court has put it is that the exclusionary rule was part and parcel of our constitutional rights, and that without an exclusionary rule, the police would essentially have a license to break into people's homes and illegally seize evidence. The exclusionary rule is a judicially created remedy designed to deter illegal police behavior by taking away any incentive for police officers to illegally search and discover evidence that they might want to use at trial.
All right, so within, like, when they talk about the exclusionary rule here, about the idea of, like, what is, like, kind of, like, warrants or what kind of determines is, like, kind of a reasonable search and seizure, all right? Generally, after Mapp versus Ohio in 1961, the kind of the commonality is the idea that if somebody needs to search your home, all right, for kind of possible illegal activity, that they should have a search warrant. All right, which you guys have all probably heard before. The idea of legal document describes the place to be searched and the items to be seized. So Dalry Mapp, who was the Mapp in that, was the evidence that was seized from her. There was like what they call pornographic material. That wasn't kind of like what they were looking for, but they kind of added that on, all right, to the kind of the items that they uncovered in her home. And so this, she basically said that was not what was kind of being looked for, and so therefore that should be excluded from the kind of the evidence at hand. All right. So generally, after Mapp versus Ohio, the idea is that the police, if they have to enter your home, they have to say where it's at specifically and what specifically they're looking for. So let's say if they're looking for like your running guns or whatever like that, and they find heroin. All right. If they don't have that down, they can't take that. Now, also, too, things have changed over time. At times, it could be easier to get a warrant, later to come back for that. It's all those are a number of court cases that, at certain times, depending upon what judge is hearing this, all right, interpretation of certain statutes can result in different kind of outcomes, if you will. But generally under the Fourth Amendment, it's the idea with the search warrant. So tomorrow and Friday, I'm going to do another DBQ here, and this is basically kind of, we're going to kind of look at kind of a particular case and determine whether this was kind of warranted a kind of legal search and seizure and stuff like that. So that's what we're going to be doing tomorrow with this. So we'll kind of come back to the kind of the Fourth Amendment. Fifth Amendment has a lot to unpack. All right, the Fifth Amendment, kind of like the First Amendment, has multiple kind of clauses in there. And the idea with the Fifth Amendment here is in kind of what they call due process. All right, the idea that people are kind of like basically the kind of actions, the steps that go into somebody through kind of like a kind of court system. So it protects against a number of things, like self-incrimination, right? Do you ever hear when people like start watching TV like shows and like, I don't know, whatever, and someone says, I plead the fifth? Have you ever heard that term? Yeah. That's basically you don't self-incriminate yourself. Say, I plead the fifth. In cases generally with that shouldn't, in jury cases, that shouldn't have a reflection on the person, right? Also, in certain court cases, the idea you don't have to take the stand. All right, if in certain cases, all right, you also have the right to a grand jury. This is particularly focused, Fifth Amendment particularly focuses on criminal cases. So there's a lot of things that kind of go into what we refer to as due process. All right, due process law. We basically kind of the steps and the rights that are basically afforded individuals within a kind of like court system, federal court system. All right, so I'm going to play this kind of crash course here that kind of talks about these things, and I'm kind of like.
Hi, I'm Craig, and this is Crash Course Government and Politics, and today we're going to try to define one of the trickiest terms in government and in the Constitution, and that is certiorari. No, we've already defined that. Due process of law. On the most basic level, due process is what it means to have a fair trial, but as we'll see, it's a lot more than what goes on in the courtroom. Due process can refer to any type of legal action, but we're mostly concerned with criminal procedure here, mainly because it's always the government that brings criminal charges. Last time, we looked at search warrants and probable cause, and it's fair to say that this is the beginning of due process, but search and seizure is the Fourth Amendment. In this episode, we're more concerned with Amendments 5 and 6, and most important, we'll be explaining some of the aspects of the legal system that you've probably heard if you've ever watched a cop show. Before we move forward, let's look at the 14th Amendment. You'll remember from episode 23 that the civil liberties enshrined in the Bill of Rights initially applied only to the federal government. State governments could violate them until the cows came home, which in 1789 is how they measured time. This changed with the 14th Amendment, which allowed the court to incorporate the rights against the states over time. This is especially important with criminal procedural rights and liberties, because most of the time criminal cases are brought by state governments. So the part of the 14th Amendment that applies here is, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. You can see that it refers directly to states, and that it says they can't deprive a person of life, kill them, liberty, lock them up, or property, fine them and take away their stuff without due process of law. But what does it mean? Serious fans of jurisprudence, and you know who you are, know that there are two concepts of due process floating around out there. The first is substantive due process, which is a blanket prohibition on government infringing on fundamental liberties. If you think that this is kind of vague, you're not alone. The courts generally don't like to uphold claims based on substantive due process because then they'd have to define what it actually means. Procedural due process, on the other hand, is a different story. Under this doctrine, the court looks at whether the government acted properly in applying its power. Court decisions establish procedural limitations on law enforcement and adjudication. If the government followed these procedural rules, then in general, the courts will say that they didn't violate your due process rights. But what procedures do they have to follow, and where do they come from? When it comes to due process, the Fifth Amendment to the Constitution does most of the heavy lifting. Here's what it says. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces, or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb. Nor shall be compelled in any criminal case to be witness against himself, nor be deprived of life, liberty, or property without due process of law. Nor shall private property be taken for public use without just compensation. Notice that the second to last clause mentions due process of law in language similar to what you find in the 14th Amendment. Imagine that. And the rest of the amendment basically explains a lot of what due process is. Let's go to the thought bubble. The first clause basically says that if you are charged with a crime, you are entitled to a grand jury that must look at the evidence and decide that there is enough to bring you to trial. If the grand jury decides that there is enough evidence, they issue an indictment. And this means that unless you make a plea deal, you will have a trial, which almost never happens because people usually make plea deals. We don't have to talk much about cases in the land or naval forces. This just means that soldiers and sailors who commit crimes get tried in military courts, which becomes quite important when you are talking about potential terrorists, but that's for another day. The second protection this amendment gives us is against double jeopardy. Not the good Alex Trebek kind, the bad kind where the state tries you for a crime, loses its case, and then decides to try you again for the exact same crime. What is unfair? Legal types like to say that the government only gets one bite at the apple because legal types love fruit. In case you're wondering, the double jeopardy clause only applies to convictions. If there's a mistrial in your case, and as a result you are neither convicted nor acquitted, the state can bring you to trial again. The next clause, saying that you can't be compelled to be a witness against yourself, is the most important one, at least in the way we think about due process. This is the protection against self-incrimination, and it's what we mean when we say that someone pleads the fifth. The idea that you can't be compelled to confess your own guilt is the basis of the famous first sentence in every arrest you ever see on TV. You have the right to remain silent. Anything you say may be used against you in the court of law. You'll remember this morning comes from the 1966 case Miranda versus Arizona. The last clause in the Fifth Amendment is the just compensation clause, and it only means that if the state takes away your property, say to build a freeway for your front yard, they can do it, but they have to pay you for it. This is the basis for what's called eminent domain, which is fascinating, but I don't have time to go into it here. I'm a busy man. Thanks, Thought Bubble. So you can see that the Fifth Amendment goes a long way toward protecting us from the state using its power to put us in jail arbitrarily. Just think for a minute about what the state could do to force confessions or to keep bringing you to trial until they get a conviction, and you can see how important these rights are. The fear that the state would use its legal muscle to take away our liberties was so great that the writers of the Bill of Rights needed 2 amendments to cover it all. 3 if you count the 7th Amendment, which guarantees the right to a jury trial. If the 5th Amendment provides more general procedural protections, then the 6th Amendment is more specific. Here's what it says. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So this explains what a fair trial looks like. It must be speedy, which most states define in their constitutions, but usually means that you can be held for 45 days before you have to have a trial, unless you waive this right in order to prepare a stronger defense. The trial should be public, no royal courts or star chambers, because transparency is supposed to make them work better. You have the right to a jury of your peers, not a jury of policemen or government officials or people who are basically likely to convict you, although you can waive your right to a jury. And the trial is supposed to be where you committed the crime, although this doesn't always apply exactly. You have the right to know what you are charged with, which makes total sense because if you didn't, it would be pretty hard to put up a good defense, and you must be able to cross-examine the witnesses brought against you. Probably most important, you have the right to an attorney, although according to the case Gideon versus Wainwright, this only applies in felony cases, which I suppose makes sense because these are the ones that are likely, if you lose, to result in loss of liberty or even life. Because the legal process, as I hope you're beginning to see, is kind of complicated, you really need a lawyer if you're ever going to get arrested and charged with a crime. That phrase, the right to an attorney, is also part of the Miranda warning. So this seems like a good place to try to explain the Miranda case. I'll try to be brief. Stan made that pun. Terrible. Miranda was arrested on suspicion of kidnapping and rape after being identified in a police lineup. The police questioned him for 2 hours, at the end of which he confessed to the crime. He was never told about his due process rights, specifically the protection against self-incrimination, which is what he did in his confession. The confession was the main evidence used to convict him, and Miranda was sentenced to 20 to 30 years in prison. He appealed, while his lawyers did, claiming that his Fifth Amendment rights were violated. The court agreed, and they went a bit further, ruling that you don't really have due process protections unless you know about them. This is why the police, when they arrest you, have to tell you about your right to remain silent so you don't incriminate yourself, and your right to an attorney provided by the state if you can't afford one. Again, because if you have been arrested, you're going to need one. If you're going to take away one thing from this case, don't make it my wallet, because that will get you arrested. It should be this. If the police take you into custody or even want to ask you a few questions, you should ask them if you're under arrest. If they say no, then you can walk away from them. If they say yes, you are under arrest, the very next thing you should say is, I'd like to speak with a lawyer, and don't say anything else to them until you have a lawyer there. Well, you might be able to ask for coffee.
Yeah, I'm gonna keep it moving here. So, again, within the Fifth Amendment, all right, under kind of concept of due process, like with the idea of like no self-incrimination and such, you have to, there's certain steps that are expected. Now, does this always happen? This is why we have court cases and things are brought up in front here. The idea is that you have to go through certain here. An indictment, which is formally accuses someone of a crime, usually occurs after a grand jury, particularly when it comes to kind of certain cases, criminal cases here. A grand jury does not, it just basically sees if there's enough evidence for a trial. All right, and so if the grand jury determines that there is, all right, then an indictment is issued. All right? And so that person is kind of like formally accused, is formally kind of brought in kind of in front of a court, or they said there's certain like things where we can make plea deals, right? The kind of like the kind of our judicial system. This is the very kind of basic kind of cliff notes with that. All right, lawyers can delve into this a little bit more in detail and kind of know certain kind of shortcuts and loopholes here. But the idea under the Fifth Amendment is that there needs to be a grand jury to determine if there's enough evidence to issue an indictment. All right. Like I said there, the idea also with the Fifth Amendment, with the fifth, self-incrimination, having to testify against oneself, that is protected under the Fifth Amendment. You don't have to do that. You can forego taking the stand in certain cases. Also, the concept of double jeopardy is mentioned in the Fifth Amendment. Double jeopardy is the idea of being tried for the same crime twice. If you're found not guilty of that crime, then the idea is that the state can't bring another charge, charge you for that same crime, trying to find you guilty multiple times. Now, there's a difference if it's a criminal case and then later it kind of turns into what we call a civil case. All right. If there's what they call a hung jury, which basically means that there's no one, and we'll talk about this when we get to chapter 7, in kind of like in trial juries, it's usually a 12-person jury, and it says it has to be unanimous. All right. If one person basically is like, I don't, kind of holds out with that, if they can't come to a unanimous decision or whatever like that, that's what they refer to as a hung jury. And then it can be tried again for that. All right. Like I said, the whole concept within the Fifth Amendment is under what we refer to as due process of law, fair treatment. That's the idea. No person under the kind of Fifth Amendment should be denied life, liberty, property without due process, without these certain steps. Again, there's been certain court cases like they had mentioned, the kind of Miranda versus Arizona, which is that whole idea where you read the Miranda rights. So, and there's multiple court cases that basically kind of argue that people's due process had basically been violated in certain cases, so they have to basically kind of each time kind of add to this definition to a certain extent. All right, so the Fifth Amendment is kind of a catch-all kind of amendment. Eminent domain is also mentioned in the Fifth Amendment, which is the idea that the government is not supposed to take your property without fair compensation. So, like the big thing, a lot of times, eminent domain is the idea of, let's say, they want to tear down your house to build a highway through there. The state is supposed to pay you for your home for fair value. Doesn't always happen that way at times, all right? And there's people who, in certain cases, people hold out. The idea is just what benefit for the kind of the general welfare of the public, So this is, and this recently, probably about 20 years ago, there's been major kind of court cases dealing with eminent domain for things like expanding airports, like over in St. Louis. There's been kind of issues with that. So this is kind of mentioned in the Fifth Amendment. All right, the idea you're supposed to get fair compensation for your home or your property or whatever the government wants to use. All right. Sixth Amendment is this idea of a fair and prompt trial by jury. If you're kind of accused of charges, you must, you're basically informed what those charges are. Also, too, within a kind of a jury trial, you basically get to question all witnesses. So Fifth and Sixth Amendment, like the video said, are kind of tied in together in that sense. So you definitely, basically kind of the and in certain cases, people waive a jury trial, all right, in certain cases. But the idea again with juries, and we'll talk about that in a little bit more detail in chapter 7, is that that the idea is you're supposed to be basically judged by your peers, all right? That's a general term. All right. Unfortunately, like for jury trial, like if you did to join a jury or ever be picked for a jury, you're generally you have to be kind of a registered voter in a lot of states. And I'll talk about with that when we get to chapter 7. All right. Amendment 7 provides for trial jury what we call civil cases. 6 is mainly kind of criminal cases. 7 is dealing with things that are kind of like being sued. You have the opportunity to have a trial by jury if it's over a certain monetary amount, and that changes over time. Right. So 5, 6, and 7, all right, are dealing kind of basically with kind of the process of kind of going through the legal system. All right. 8th Amendment protects against excessive bail. Bail is basically money or property accused gives to hold the court for, and which is like kind of like like you bail and bond. You know, like generally was like 10%, you know, bail is 10% of what the bond is. In certain cases, depending on the crime, some people are not afforded this, but this is the idea for certain cases you should have the opportunity to basically pay your way out. But that doesn't exempt you from like a trial. That basically guarantees that you'll show up for your trial. All right. If you jump bail and you don't show up in court, you don't get to get that money back. Is the idea. And then also protects against what we call cruel and unusual punishment. All right. The idea that you're not to be basically kind of you know, this tries to protect against you know, like torture and stuff like that. And that's kind of like, you know, related into the Eighth Amendment. A lot of times people get the Eighth and Fourth Amendments mixed up for whatever reason. All right. Ninth and Tenth Amendments are kind of catch-all amendments. So this is like, well, what we can't think of here, we'll just kind of let 9 to 10 to kind of keep it somewhat vague. Ninth Amendment, rights not specifically listed in the Constitution are given to the people. All right. And then the 10th Amendment deals with kind of states. So the next one, if you type down, just put 10th Amendment. All right. Submit this to me later. All right. I'll send out the recording if you need to. So there's the 10th Amendment. All right. See you guys. Be careful walking those steps. I almost wiped out, so.